Good afternoon, everyone. It's Pablo.zuanic, cannabis, hemp, and CBD analyst at Zuanic Associates. I have the pleasure of introducing to you Michelle Bodian. She's a partner at the law firm Vicente, LLP. Michelle, welcome.
Hi, thanks for having me.
Sure. Look, for the audience out there, whether you're in Spaces or in Zoom, feel free to send questions through email in Spaces, post them in Twitter. You can put them on the Zoom chat. The purpose of this call is a bit of a teaching, right? For the audience that is not so familiar with hemp derivatives, particularly intoxicating or psychoactive hemp derivatives, is to hear about the facts, the lay of the land from a legal point of view, what are the arguments, and that's the way we are approaching this call today with Michelle Bodian from Vicente. So just to be clear on that, the other reason some people ask me, like, why was I've been covering mostly cannabis. Why am I talking about hemp derivatives? Well, a number of cannabis companies are entering the hemp derivative space, right? We've seen Wana, part of Cannabis USA. We've seen Kiva. We've seen Green Thumb licensing their brand Incredibles. Curaleaf recently have a hemp platform. So they are participating in the industry. And hemp, of course, as an industry, it's a sizable industry, right? Creating jobs, paying taxes. So we're looking at it also from an unbiased, neutral perspective, but we think that to the investment case on stocks, whether it's CBD, hemp stocks, or cannabis stocks, this should be value added. So that's the angle we are taking from. We have no hidden agenda, and we're not necessarily trying to take a specific side. So sorry, Michelle, for that long introduction on my side. So let's start with you now and just tell the audience a bit about yourself and what you do at Vicente.
Sure, I'm a partner in our East Coast office, split my time between Boston and New York, a couple different hats to kind of cover both sides of the plant. So co-chair of the Hemp and Cannabinoid Practice Group, as well as East Coast, specifically New York and Connecticut marijuana licensing and regulatory, some Massachusetts, some Maryland. And then Vicente, formerly known as Vicente Cedarburg, as a law firm founded more than 15 years ago, originally out of Denver. We are, hemp, marijuana, and psychedelics focused. That's all we do day in and day out across the country in our 9 offices.
Understood. Thank you. So look, let's start with the Farm Bill 2018. I know we're going back 6-7 years almost now, but just a bit of history there. Recap what it did for hemp. The boom bust that we saw for hemp farmers at the beginning. It seemed the focus initially on the derivative side was mostly on CBD, non-intoxicating. Then we had all this rise of Delta-8 and other intoxicating hemp derivatives. But just talk about, what did the Farm Bill from 2018 do for the industry and what's happened since then? Thanks.
Yeah, absolutely. I mean, you could even go further back to the 2014 Farm Bill, which was a research-based program. So what the 2018 Farm Bill said, you don't just have to do research with hemp, that's really, you can now commercialize it as an agricultural commodity. So 18 Farm Bill, expressly legal, states could set up their own cultivation programs, or you could defer cultivation to USDA. But what this did is essentially legalize hemp, removed it from the Controlled Substances Act, set up a commercial framework. And then where the 18 Farm Bill, what it did and did not do, it does stop at the farm gate. So it talks about cultivation only. Within the 2018 Farm Bill, it preserves FDA's authority to regulate finished product, because the Farm Bill was focused on the scope of USDA, meaning agricultural commodities, not FDA, and finished products. So what it did, legalized hemp, removed it from the Controlled Substances Act, but really focusing on the cultivation, on-farm production, wasn't focusing on extraction, manufacturing, retail, sales, although that did come later, because when you remove something from the Controlled Substances Act, good things happen to an industry.
Right. And just to be clear there, in terms of the definition, talk about, that 0.3% on a dry weight basis of Delta-9. How does it work? How do they define that? How do they actually measure or test for that?
Sure. So 2018 Farm Bill overarching law that was addressing this, the legal definition in the 2018 Farm Bill, the dividing line between hemp, not a controlled substance, marijuana, still considered a controlled substance, is what, hemp, all derivatives, isomers, on a 0.3% Delta-9 dry weight basis. That was what was in the 2018 Farm Bill. Implementing regulations that USDA came out with did then expand that definition. So it went beyond Delta 9 THC and expanded that to a total THC definition, meaning you're actually going to use a formula to multiply Delta 9 times 0.877, which is the weight of the molecule, to then actually get a total THC. So that's a lot of science words there, but basically saying the dividing line between hemp and marijuana is the amount of THC within the plant on a dry weight basis at 0.3%.
Right, and just to be clear there, so in terms of the USDA, right, their role was, as you said, to the farm gate, right? They are overseeing the cultivation side. But what happens after that, was that a bit of a no man's land, or was it really, according to a Farm Bill, clearly attributed to oversight by the FDA or other bodies in terms of finished products?
Sure. I think there was the intent that FDA was going to pick up the ball and run with it. So it gets off the farm, it's on the truck as biomass, it's going to go get extracted, it's going to get manufactured, it's going to get incorporated into finished product. I think the intent, and there's Farm Bill, 2018 Farm Bill language on hemp is about 4 pages of that. You got a couple sentences that said, hey, don't forget FDA still has a role here. So those couple sentences are pretty meaningful. And the intent was FDA would step in, as they do for all food products and all dietary supplements we consume, and have a role in oversight.
Right. But on that point, and I don't want to jump ahead here, but the FDA, has opined in the case of CBD that they want Congress to act, right? If someone wants to classify CBD as a dietary supplement, FDA is saying it's not ready to do that. That has to be done by an act of Congress. But has the FDA said anything in general about other hemp derivatives?
Sure. So after this happened, people started growing, people started extracting, CBD products started showing up. That was the first cannabinoid, hundreds of cannabinoids in the plant. CBD was kind of the new kid on the block, the one that came out. There was proliferation of products. When that started happening, FDA did come out and say they've looked at everything in their back office, and it's their position that CBD and THC cannot be added to food and dietary supplements because of what's colloquially known as the drug preclusion rule. So if something has started clinical trials or is an active ingredient in a drug, in this case, Epidiolex or Sativex, then it can't be then sold over the counter. So if someone's gone through clinical trials, created a drug, you can't then just start selling that same version in FDA's mind at a gas station or liquor store. And so they came out with their position on the topic kind of soon after the 2018 Farm Bill. Obviously, there's pushback from the industry on that interpretation. Then there are some exemptions. But that was FDA's position on just those 2 particular cannabinoids on CBD and Delta 9 THC.
Right. So look, I mean, on that point, and here we're going to talk about, the legal status at the federal level, and then we'll discuss it also at the state level, right? So at the federal level, the FDA has opined on some of these subjects. The DEA has also opined. And of course, we've had the legal system, right? The 4th Circuit recently opined also on THCO, for example, right? So as we answer these questions, maybe we can differentiate between Delta 8, THCA, THCO, and other cannabinoids. But the big picture question here, in terms of the FDA, would you say that to some extent they have dropped the ball? I mean, they were in charge, according to a Farm Bill of 2018, of regulating the finished products, and they haven't. They didn't do it with CBD. They punted to Congress, if you want. And on the other products, I'm not so sure they've been as clear. Any thoughts on that? Or do you
Sure, and I should always give the disclaimer, I'm a former regulator, so I am very kind-hearted when it comes to the burden on regulators. So I don't know if they necessarily dropped the ball. I mean, they reviewed what they had in front of them, and it's their position that they came out with a position that it's prohibited. Industry moved forward despite despite FDA's prohibition. So in their mind, if their mind it's prohibited, there was nothing for them to further act upon. Industry was submitting data of saying why one of the exemptions should apply. Legislation has been introduced at the federal level several times. New legislation is coming in a couple of weeks. Like, people are trying to create a new pathway to say these are new cannabinoids. Maybe it shouldn't go under our standard food program or our standard dietary supplement. But yeah, I think a lot of the hemp industry does feel like FDA hasn't picked up the ball and run with it in ways they could have from FDA's perspective, they said, we've looked at everything that's in our mandate, that's in existence, and we don't see how we can get it done within the framework of what exists. So Congress, give us a new framework, let us help you create the new pathway, and then we can get these products approved as food and dietary supplements.
Right. And will that be as simple as Congress saying, I mean, through an act of Congress saying, well, we, Congress, believe that CBD and other and I'm talking about CBD specifically, right?
Yeah.
Non-intoxicating hemp and non-intoxicating CBD, that if an act of Congress said this is a dietary supplement, they can do that. I mean, that's enough for the FDA if Congress is saying it is, although
yeah, I mean, it's simple enough. If you change the law and say, yes, you can do this, drug preclusion doesn't apply if you can prove X, Y, or Z, you know, yes, there's a way. If the law changes, FDA then can act.
Right. Just and staying on the same point now, moving on to intoxicating hemp derivatives and or I don't know if you use another term, psychoactive, but just remind us what has FDA said on the subject of intoxicating hemp derivatives and what the DEA has said.
Sure. Brief summary. So, you know, that drug preclusion applies to both CBD and Delta-9 THC. So in their mind, both these cannabinoids are active ingredients. You know, obviously one of them is intoxicating, one of them is not, but in their mind, both these cannabinoids equally prohibited in food and dietary supplements. DEA's perspective, at least on hemp Delta-9, is it is exempt from the Controlled Substances Act. But we do have a whole host of other cannabinoids we haven't gotten into really in much detail. Delta-8, THCA, THCO, HHA, THCP, THCJD. So there's a whole alphabet soup of other cannabinoids. So far, FDA has only issued, their enforcement to date has primarily been warning letters. The number of those warning letters vary, saying the addition of certain cannabinoids into food products or dietary supplements are attractive to minors, making prohibited health claims, medical claims, the products will cure cancer or COVID, but cannabinoids specifically, they've issued warning statements for products containing CBG, CBN, CBG, the commonly known as non-intoxicating cannabinoids. And for the intoxicating cannabinoids, their warning letters to date have been limited to Delta-8 and Delta-9 THC.
Right. And their warning letters have been, in the case of just CBD, to my knowledge, the warning letters is about companies not making claims around the products, but not necessarily prohibiting the product. In the case of Delta-9, what have they said specifically in terms of their warning letters?
I mean, same thing. It does say it says CBD and Delta-9 THC cannot be added, and same with Delta-8, cannot be added to food or dietary supplements because they haven't gone through the proper procedures to get approved to be used as a food additive. That said, they're saying the reason we're sending you the warning letters is because you also did something else wrong, and that's why you're on our radar. They do all start with the same intro, couple paragraphs about how FDA feels about these cannabinoids generally, but the reason these specific companies, typically online retailers, are getting these letters is because they're making health claims, PTSD, COVID, cancer, depression, anxiety. And I will say these warning letters go not just to humans, obviously the letters go to humans, but the products also, if you're saying these are pet treats or pet medicine, the one most recently, a couple weeks ago, was targeting a company that was saying, the CBD oil for pets would cure Lyme disease and other things. And that, again, would be positioning this as an unapproved drug because of the claims they're making.
But at the federal level, what power does the FDA have in terms of enforcement, other than beyond sending these warning letters?
Sure. At the congressional hearing last week, FDA testified that they can go pull product from shelves. I'm not sure if you caught all that testimony in the articles that followed. Typically it's like a grading scale of what they can do, what they do in practice, regardless of their authority. So first shot, warning letter, tell us how you're going to react. There was one big effort a couple of years ago, Operation CBD Seat. Clever title, spent a lot of time thinking of that, I'm sure. That did result in some civil fines, as well as some product recalls, but that was the rarity. That was 6 companies out of, however many since 2018 that have been in this space. Typically, it's just a warning letter. FDA's authority generally, and I'm sure you see it in the media with, most recently, lead in applesauce pouches. I got 2 toddlers. You know, they could do recalls, they could do fines, criminal penalties can attach for selling adulterated and misbranded products. That's rare, but it is possible.
Yeah. Now, and staying also at the federal level in terms of the court system, talk about recent decisions that maybe have pushed back on the DEA and the FDA.
Yeah, and I hope for our viewers watching that, you know, and I know you're more focused typically on your presentations on marijuana, but one thing to take away from hemp is I always say it's a whole lot more complicated in hemp land than marijuana land, in the overlapping jurisdiction and each state. We haven't gotten to state, we're still at federal. So federally, we also have courts and they get a role here. We have federal courts and federal courts are deciding things differently right now. We've got 2 federal court opinions right now, one from the 9th Circuit, one from the 4th Circuit. Each federal circuit court encompasses certain states under its jurisdiction. So 4th Circuit, we just got a decision a couple weeks ago that borrowed very heavily from the 9th Circuit opinion. And within the 4th Circuit, you got South Dakota, South Carolina, North Carolina, a bunch of other states. But in essence, the opinion said, hemp is hemp and anything downstream still meets the definition of hemp and it's exempt from the Controlled Substance. Obviously, Controlled Substances Act, a lot of nuances and detail there, but it is saying plain language of the 2018 Farm Bill said hemp and it's all of its derivatives. The dividing line between hemp and marijuana is back to that 0.3% Delta 9 standard. And, you know, if you meet that standard, but have a whole heck of a lot of Delta 8 in the product, that still meets the definition of hemp, and it's still exempt from a controlled substance. But the judge did note it's going to be a product specific analysis. So you're going to have to be able to prove that it's hemp, meaning it came out of the ground as hemp. You have certificates of analysis that prove that it's manufactured in a facility. So it stays hemp, but you're going to have to be able to prove along the chain through some chain of custody documents that it's actually hemp.
And just on that decision, I think there's a couple of other ones we can discuss also, but on that one specifically, I suppose that's going to go through an appeal process, maybe talk about what that process would be like. But also in the meantime, because of that decision, that would mean that in the jurisdiction of the federal court, the FDA or the DEA could not enforce their views on hemp, and the court decision would stand for the time being. Is that true or not?
I mean, big picture, yes. Practically speaking, states are going to act how they're going to act. I mean, the 9th Circuit decision was a couple years ago. You know, post 9th Circuit decision, we still had states limiting the amount of THC in their products, even the states under the 9th Circuit. So yes, kind of big picture, that's how it could and should work. But practically speaking, probably not, although states are going to give some deference. We actually just got an attorney general opinion out of South Carolina yesterday. And a lot of that opinion is citing very heavily to the 4th Circuit, South Carolina being in the 4th Circuit. They're saying, well, if the federal courts are saying this is what the definition of hemp, you know, hemp is, why are we to stand in the way and have a different definition?
Right. And just before we move on, in terms of, would that be the biggest decision recently to focus on in terms of, you know, that's helping the hemp industry if you want?
Yeah, absolutely. And it's only a couple weeks old. And this also was the first one post Chevron deference. You know, it's kind of being eroded generally through the courts, Chevron being a Supreme Court case that said if, you know, again, boiling this all down real simply.
Loper, yeah.
Yeah, if it's saying if an agency is ambiguous as to an interpretation, the agency gets deference. Sorry, if the statute's ambiguous as to how it can be interpreted, the agency gets deference to their interpretation. So Loper Bright, the recent Supreme Court decision said, maybe not, like, you know, we should look at this with fresh eyes. So this is the first federal court decision on hemp post Loper Bright overturning Chevron, rolls off the tongue. So yeah, pretty interesting, saying, you know, we're not gonna, DEA's been writing letters, we haven't touched on that, about the legality of cannabinoids. So the 4th Circuit said that's nice, DEA is writing opinion letters, but in our mind, you know, these letters don't overturn the plain meaning of the 2018 Farm Bill. We're going to go back to statutory definitions and not defer to the agency and how they're interpreting it.
And again, in terms of the appeal process for the 4th Circuit decision, what comes next there?
I mean, there's the Supreme Court. You know, there is one hemp product tangentially related. It was a failed drug test related to the consumption of CBD. We will get that opinion I think it's due for oral argument. It's in a few months, and that'll be the first hemp CBD product case before the Supreme Court. But other than that, yes, we'll, whether it's the next farm bill or whether if a case gets selected to be heard, another case before the Supreme Court, we could get further clarity from the federal courts.
Right. And like you mentioned that we're going to move the discussion to a state level, but still staying federal. In the case of the AG from South Carolina, you said he made reference to the Fourth Circuit decision. Have we heard of other AGs do the same, or that's exception right now so far?
So far, no. I will say the decision's like 3 weeks old, so we probably will. And that South Carolina is the first one. That he cited very heavily to an Iowa hemp product case, very heavily to the Fourth Circuit, a little bit to the Ninth Circuit. But that's the first one to say, hey, we're deferring to how federal courts have interpreted this.
Yeah, understood. For those of you listening through Zoom, remember, please, we don't take live questions. So if you have a question, please put it in the chat room. You can also email it to me, or you can also, if you're in Twitter, you can put it on Spaces, and we will see it there, right? So just to clarify that. But if you have a question, we'll be happy to try to answer it, Michelle. But put it on the chat room if you're in Zoom, please. So let's just move on at the state level. So now what we're beginning to see, and of course we have to talk about the Farm Bill 2023 or 2025 now, but at the state
2026, we don't know.
That's how far it could go, yeah. So just give us the synopsis, if possible, at the state level, right? We're seeing in some cases attempts for blanket bans. In some cases we're seeing regulation. In some cases we're seeing stays against those bans. Just talk about what's happening at the state level, and I'm not going to make you go through each 50 state, right? But
I can do it. I swear, this will be my moment to shine. Yeah, I mean, post 2018 Farm Bill, I think people expected FDA to step in and regulate. They didn't. Their position was these products are prohibited. The industry launched anyway, despite this prohibition. So states stepped in. Kind of 18, 19, a lot of this not being intoxicating hemp products, CBD, CBN, CBG products. But even then, states were stepping in, some regulating, some prohibiting, some saying, not my problem, we're only regulating cultivation. So the patchwork started really post 18 Farm Bill. Every year, states addressing this at the legislative level, some states at the agency guidance level or FAQs, but kind of year over year, we've seen a lot of changes over the past several years, probably 2 to 3 years post-COVID. We've seen an uptick in state legislative action addressing, hemp-derived cannabinoids, Delta-8, Delta-9, probably 2020, 2021, a lot of states were hyper-focused on Delta-8 specific legislation. So a lot of bills being introduced, some legislation passing, saying we prohibit Delta-8. Hemp-derived Delta-8 cannabinoid. It didn't necessarily also encompass other cannabinoids, really hyper-focused, just naming that one cannabinoid. Then kind of 22, 23, the trend was, well, we're not going to name specific cannabinoids. Every state just wants to come up with their own new definition of what's prohibited. Some states saying we're prohibiting synthetic cannabinoids, some states saying manufactured cannabinoids. So every state having a new fun definition that you got to dig in on. Some states saying the agency itself is going to put out a list of good and bad cannabinoids, cannabinoids, and therefore products capable of registration. West Virginia, for example, has a list of registrable and unregistrable, not sure that's a word, cannabinoids, and it's updated almost every week of them saying, here are 3 new cannabinoids the industry's created, here's how we feel about it, whether it meets our standards. So, short answer, chaos at the state level and changing quite frequently, at least every legislative session. And then once it changes at the law level, then you got implementing regulations. Georgia, for example, allows, as of the summer, legislative change allows ingestibles. That's being interpreted to be gummies and beverages. They didn't have a milligram limit at the law level, but now through implementing regulations, they're imposing a milligram limit. So even when you get through the legislative process, you have then regulations that can further change it.
Right. So just staying on that subject, so let's talk about, and again, at the state level, in terms of a blanket, what we call blanket bans, right? Where are we seeing that? I think California, New Jersey, New York, talk about that, and maybe it's not 100% blanket, but just if you can touch on that.
yeah, kind of emerging trend of the states that have regulatory frameworks for adult use cannabis. That tends to be the states where they're then trying to regulate intoxicating cannabinoids through their marijuana program. So yeah, it ends up being kind of the Northeast and the West Coast, and either saying a detectable amount of THC, like a California, or a Maryland saying if it's above 0.5 milligrams per serving or 2.5 milligrams per container, that's considered marijuana in the state of Maryland. There's an injunction there, so maybe people can keep selling if they were doing certain things. But in a lot of these emerging states, New York, Maryland, the milligram limits are getting set very low, such that it's kind of equating to a blanket ban on Delta 9, Delta 8, CBD, CBN, CBG. A lot of these, original cannabinoids are still being permitted to be sold, but some of these more exotic cannabinoids are being funneled through their adult use market. And then there's certain outlier states, Idaho, Alaska, Washington, DC, where any amount of THC is being considered marijuana. Whereas in states like New York or Maryland, they're setting it super low dose at that 2.5, but it's not zero. And then we have a host of states where it's being set at zero.
Right. So look, I mean, I know there's a lot to unpack there, but in terms of when you're talking about the attempt by some of these regulators to have the hemp derivatives be regulated by the cannabis agencies or commissions at the state level, what does it really mean in practice? And I'm sure it varies by state, but does it mean that they have to be sold through dispensaries, that the testing is going to be done by cannabis, THC, cannabis-related labs? The distribution is controlled by the Cannabis Commission. I mean, that it's not sold in smoke shops. Is there any nuance there, or it's pretty much that's what it really means in practice?
Yeah, I mean, I think there's the intent and then what happens in practice. What happens in practice means the manufacturers and retailers do pull out of the market. Manufacturing and retail shifts to the cannabis industry. I think direct the D2C sales to customers are still happening within that market, because D2C sales are very hard to police and enforce. So what happens ends up being there's some group of these products are so sold on the market because there's not a lot of enforcement, still sold in person, either because people didn't know the law changed or they knew and don't care and they're going to continue selling. But at the manufacturing and retail level, that then does, those businesses that were manufacturing hemp cannabinoids under a state license, or maybe not with a license, or retailing a hemp dispensary, those businesses do end up shuttering and moving, and those products, if they want to, would come back through the cannabis agency under their jurisdiction. Usually those businesses just fold, move to a different state, or move their business online. I don't think all of a sudden, one for one, those products are shifting over into the cannabis framework.
Right. And look, just in terms of states where the hemp industry through the court system has succeeded in having courts issue a stay on those bans, is Maryland the only exception, or are there other states where
Maryland, Alabama, Arkansas, I mean, to be determined on New Jersey, California, Missouri, which would probably be the next three states with some legislation. There was a win in New York on emergency regulations, but the win lasted about 2 weeks because that was a technical win, and then it moved to permanent regs. But yeah, there's been a few states where either the procedure was challenged or the substance was challenged. Kind of on balance, most of the litigation, has gone in the state's favor rather than for the hemp industry, but there has been a few pockets of where individual operators and businesses have gotten that injunction.
But in the case of Maryland, with that injunction, how much time are we talking about? Does that stay in place for what? 6 months? Is it 2, 3 years?
I mean, it's in place till it's removed. That one, though, it's still in place, but the injunction only applied to those businesses that were selling in the state of Maryland before July 1st, 2023. So new businesses would not have the opportunity to participate in the market. The businesses that could, if the agency came and asked, could prove they were already in business in the market in Maryland selling before July 1st, 2023. So even with these injunctions and the stays, there's a narrower group of people it's applicable to. It doesn't typically throw open the doors for everyone.
And then besides the court system, right, there's been cases where the politicians have not agreed, right? In the case of Florida, the governor there vetoed the ban. Maybe you can elaborate on that. And in the case of Missouri, to my knowledge, there's also some discussion still going on there between the legislature and the governor, right? If you can talk about that.
Sure. Yeah, Florida hemp product laws, testing, labeling, the piece that we're missing there were taxation, a milligram limit, and a list of permitted or prohibited cannabinoids. So there was legislation that was introduced that would have set a milligram limit, 5 milligrams per serving, 50 milligrams per container. And ultimately that legislation, passed through the legislature, but then the governor did end up vetoing it. Legislative vetoes are pretty rare. I think Florida is going to be back in legislative session, and to be determined if new legislation is going to be introduced or where that ends up. But yeah, Florida didn't end up in a veto. Missouri governor came out with an executive order looking to ban. Well, a little unclear what he was looking to ban, but I think at the end of the day, it's a lot of the cannabinoids we're talking about here. He instructed his alcohol agency to create emergency regulations in order to implement that ban. The ban went into effect on September 1st. The Secretary of State in Missouri rejected those regulations actually twice. Again, probably on technical procedural grounds, maybe not on substance. The governor said, okay, let's keep trying to work through the regulations, but in the meantime, the state did move forward with enforcement on trying to pull these products from the shelf, and again, trying to funnel it through their adult use marijuana system. There's a couple articles coming out last week that looks like one of these enforcement raids did unfortunately happen on 9/11 at a VA hospital or VA, I don't know what they're called. VFW, I guess, there you go, at a VFW, and they ended up pulling product, sign of like probably not what they intended, probably not where the target location they were searching for. But Missouri is moving forward even with the regulations getting rejected. So yeah, back to your original question, what's going on at the state level? Yeah. Lots all the time.
Yeah, let's stay there. And I thought cannabis was complicated, but I see that.
This is what I say. It's much more complicated here.
So, what about states where there's still, little, I don't want to say regulation, but where we haven't seen this type of bans or crackdowns? Would Texas, North Carolina be in that category, or?
Texas has pretty robust regulations. I mean, they have testing, they have labeling, they have registration. Yeah, so kind of Texas, similar to a Florida, the pieces they're missing is a milligram limit, taxation, and what cannabinoids are permitted or prohibited. I'd say that's a little different than a North Carolina that doesn't have a consumable or finished product regulatory framework. So in Texas, there is the Department of Ag, Department of State Human Health Services. So there are two agencies in Texas. There is statute and regulations talking about consumable hemp products, finished product. Little different than some states like in North Carolina or Massachusetts, where they haven't come up with the regulations or the legal framework for how they want to regulate finished products.
And again, staying at the state level, are there any examples where hemp and cannabis are being regulated under the same framework, rules, and agency? I mean, I don't know if Michigan would be an example.
Same agency, yes, in a lot of states. New York, Connecticut, Minnesota, Minnesota and New York have the same acronym. That could have been better. Kentucky. So yeah, and in a number of states, it's the same agency. It's not necessarily the same framework. Right. There's often borrowed definitions. New York has similar, kind of the law has similar definitions. The regulations vary quite significantly. But yeah, in a number of states, there is some unity, but in no place yet. Some state has to go first, but in no state yet, this is treated as one plant. It is still bifurcated, even within agencies.
Understood. And now, look, I know this depends on people's point of views, but can we point to a state that is getting this right? And I know that, that's a bit of a loaded question because
far too loaded. Yeah. It depends on your definition of right. And, as a lawyer, my definition of right is clear rules. my clients might disagree with what the rules say, but to me, having laws, regulations, policies, FAQ, like all of this spelled out in a transparent manner, to me as a lawyer, that's what's getting it right. That's not the answer you're going to get from any brand or manufacturer or retailer.
Right. Yeah.
So I'm going to sidestep that question.
Yeah. No, before we move on here, I'm going to read some questions I'm getting online.
Sure.
Someone asking about, good versus bad actors. And I know it's a bit of I'm paraphrasing, but isn't part of the problem there's just too many bad actors out there compared to good actors in terms of hemp derivatives? And I'm reading from a question that came online, right? So maybe that's not a fair question, but any thoughts on that?
Yeah, I mean, my thought is typically the media doesn't report good things. It typically, news sensationalize bad things, unfortunately, is where we are. So I do think a little bit of this is being played out in the media where it is being reported on, things that are going wrong, not things that are going right.
Right. Okay. But I'm saying, like, assuming that hemp derivatives are here to stay, from your perspective, what would be sensible rules in your opinion? And I know I'm putting you on the spot here, but what would be sensible rules in your opinion? People typically talk about child resistant packaging, right? Lab testing. But what would be rules that would be sensible in your opinion? That maybe are not
Sure.
being.
I mean, I'd say in some of this, we don't need to reinvent the wheel.
Right.
Certain cannabinoids could be considered no different than any other food product. Once we unlock the science and can get a little bit more data, if we're saying these cannabinoids are intoxicating, we know how to regulate intoxicating products in the US. So if it's taxation, regulation, age gating, there is some things that can be looked to and parodied from alcohol and some lessons learned. So I think the things you mentioned, testing, labeling, packaging, taxation, milligrams, which sales channel can you sell this through? Yeah, there's a lot that could go into setting up a framework to prevent bad actors. But I'd say we've got a lot of liquor laws. We've got a lot of laws generally here in the US. Like there are bad actors in every industry, regardless of what laws exist.
And again, assuming we don't get action at the federal level, right? Is there any scenario where all the states agree on a similar framework that they choose this as unlikely, right?
I don't think so. I mean, I think the regulators that are charged with enforcing this would like some uniformity. They now have a trade association, Canberra, and they meet and they discuss, and that's great.
Right.
So I think the people would like to have some uniformity. I think the brands in the industry want some certainty and some uniformity, but I think that's not how our legislative process works. I think even if at the industry and regulator level want uniformity, I think state legislatures are going to do what they want to do that they think is right in that moment.
Look, another question coming through in terms of what about online sales, right? The rules may vary by state, but I can still order gummies from state X and get them in state X, right? And that jumps all over the rules.
It does. You're supposed to, if your customer is located in a state, you're supposed to comply with that state's laws. I mean, that's not hemp specific, that's just in general how laws work. But there's plenty of businesses, plenty of companies, not just in hemp, that are choosing to sell, regardless of what state laws are. People aren't paying taxes, even if they're supposed to in certain markets, generally speaking.
Yeah.
On the enforcement side, enforcement is pretty hard for D2C. It's not impossible. They do it in the context of liquor and guns and vapes. I mean, there's precedent that if a state wanted to prioritize enforcement that way, they certainly could. It's just not happening. So most businesses are taking the calculated business decision, risk reward there.
Right. Look, I'm going to read this question. It's a bit technical, but it says regarding the isomerization of CBD to delta 8 THC and delta 9 THC. Given that these cannabinoids can be chemically derived from hemp-derived CBD, how does this process affect their legal status under federal and state laws? Are these chemically synthesized cannabinoids considered new chemical entities? And what regulatory requirements apply to their production, tracking, and compliance?
I should say I went to law school to avoid science. I mean, the answer depends on what state you are. We now know there's two different federal courts that say hemp CBD, even if it's isomerized, would still be considered hemp as long as the delta 9 THC is below 0.3 on a dry weight basis. So if you're in one of the states that fall under the 4th or 9th Circuit, we know how the federal courts would view it. At a state level, it's going to depend. A lot of states have those definitions of artificial cannabinoids, synthesized cannabinoids. It doesn't mean they're prohibited. It might just be you have a separate set of rules. Colorado, there's some separate rules if you're making them. Oregon actively going through rulemaking right now, prohibited artificial cannabinoids. It's adding back in CBN right now. And in the future, it's going to continue examining this cannabinoid. So it depends. Go talk to your lawyer.
Right. Because I mean, the whole word of the synthetic term or the process of synthesization, if I can use that term, I'm sure it's a very gray area, right? I mean, someone told me as a company was making the argument that vitamin C, maybe come from orange, but that's it's a synthesization process, right? And that doesn't make it illegal. So the fact that you're synthesizing something doesn't necessarily make it illegal. I don't know if I agree with that, but.
I mean, same with isomerization. I mean, the words themselves may not necessarily be the problem. A lot of our drugs are made through isomerization synthesis. What it comes down to is whether or not that still meets the definition of hemp, whether it's permitted, at what rate, and what quantities within the product. And then that manufacturing technique itself, is that done in a safe and compliant manner? And it's going to depend on the state and where you are and how it's viewed. Right.
And look, I mean, 2 more questions here before we move on to the next farm bill. But in terms of the MSOs, any thoughts you may have there? More are getting involved in hemp directly or indirectly, or licensing their brands. It took them a while. They may have their reasons why they're doing it now. But any big thoughts? Do they face legal risk? Why are they doing it now? Any thoughts that you may have on that? I know it's a question more for them than for you, but yeah.
Yeah, I mean, I think businesses are taking various approaches. Some brands, if they're a cannabis brand, they're saying this gives us more reach to our consumers. So maybe they're turning off internet sales where they have cannabis operations, but they're selling in other markets to get brand recognition and some opportunities. Some cannabis companies have not at the MSO level, but at the smaller local level, have transitioned fully from cannabis into hemp. Some are having dual streams and having both opportunities. Some are introducing hemp product lines that they don't have in cannabis, whether it's a beverage line and they don't have a cannabis beverage, or it's a new gummy that's just going to be hemp only. So companies are taking various approaches, and other companies are saying, absolutely not. We think this should all be regulated under the cannabis framework, and they're working with lobbyists and the legislature to ensure that. So no thoughts other than everyone's doing something different right now.
Yeah. And look, and in terms of formats, I know we talked about cannabinoids, types of cannabinoids, but whether it's, hemp flower, vape, from hemp-derived products.
You got your tincture, you got your gummy, you got your beverage, you got your
any
flower.
thoughts on that? Are some categories or formats more at legal risk than others, but it applies to all of them?
Yeah, I mean, 1819, a lot of states, as they were setting up their framework, were prohibiting smokable flower, for example. So you can have flower, say in Texas, but you're not supposed to be marketing it for smoking purposes. So even in the assessment of public comment in Texas, the suggested idea was marketing the flower as a tea. So yeah, there's different form factors, pre-rolls and flowers, being kind of an outlier treated separately, tinctures, topicals, kind of more generally accepted. Topicals we didn't really get into, doesn't actually fall under FDA's prohibition. So topicals treated differently, gummies, beverages, all those ingestibles kind of more treated similarly in states.
Right. Then let's just move on to, I do have other questions that are coming up, but just on the farm bill, the new farm bill, when do you think it will be completed? What will it look like? Statu quo regarding hemp derivatives and defer to the states, or does the Mary Miller amendment succeed? Any thoughts or predictions you want to make in terms of a new farm bill?
The extension expires the end of September. We should know soon enough. I mean, the farmers generally are calling for, we need action now. We can't, the commodity pricing are pegged to 6 years ago at this point. Everything's more expensive. So a lot of the farming community, which is what the Farm Bill is intended to serve, rallying together for wanting to see movement here. You know, given where we are in the election cycle, given where Congress is on agreeing on things, most people are predicting we're going to get another extension. Up for debate, is it 6 months or 1 year? And then that does give time for, you know, the Miller Amendment to get reintroduced, a different version, industry to push back and introduce other. Like I mentioned, some standalone legislation is going to be introduced, as it has in the past, that's going to be affirmatively allowing and regulating hemp cannabinoids. So, you know, my best guess, it's not happening in 2024. It's going to be 2025. Some are now even saying prepare for 2026. I hope it doesn't get that far pushed out, not just for hemp, but for all the other commodities that are impacted, dairy, grain, corn, you know, SNAP, WIC, all of those great programs.
I know there's a lot inside the Farm Bill, right? I mean, how big is the hemp issue within the Farm Bill?
Like, and I swear this is not a setup who's anyone heard me speak before. It's like 2 pages out of 1,000. This is trending to be the most expensive farm bill. It's going to go over $1 trillion. Right. I mean, this puts this short answer like feeds America. Like this is every agricultural commodity. This is food. You know, this is SNAP program for pregnant women. Like this does everything to feed, to grow and feed the U.S. Hemp is a very small component of that. It feels big in our lives. But in terms of the grand scheme of things and the other issues that are being debated, you know, there's a lot of other important programs at play here.
Right. Now, in terms of, you know, I know in the case of cannabis, we are going through this rescheduling process, right? And we'll see if Congress wants to go beyond that, descheduling and enact legislation regarding cannabis. But do you see room for some form of compromise? You know, people pushing for legislation on the cannabis side and people pushing for the Farm Bill, you know, with these hemp derivatives, for some form of compromise that, you know, both would be that hemp derivatives would be, if you want, legalized at the federal level, that you won't have the risk of the Mary Miller Amendment, and that, you know, that the two sides, blue and red, I guess, could come together and agree on something here. I mean, do you see that as a possibility, or they're just different topics? Farm Bill,
I hope so. I mean, I think like as an industry, we're aligned on where we want this to end up. We might differ, you know, both sides of the plant might differ in how you get there. But yes, I think combined might of dollars, connections, lobbying. Yeah, I would love to see a world in which it's reunited as one plant again, as you know, it should have always been.
Yeah. But that's a utopia right now. I mean, the two, I mean, they are not lobbying together. They are lobbying against each other, right? Do we agree with that?
I don't know. I mean, I don't know how much is publicly lobbying together or apart. You know, most sessions are out right now. We'll see what bedfellows are come January. As you said, a lot of marijuana companies getting into the space. That's a different calculus that was last legislative session. You know, whether that means there's going to be change in lobbying. You know, the odd thing here, we've been talking a lot about finished product, but a lot of marijuana manufacturers are not allowed to use hemp ingredients. So even if someone wanted to use hemp CBD in their product, they're not allowed to in a number of states. Even if there's co-location issues as well, like if you wanted to get one license, one facility, and make a hemp product and make a marijuana product at the same facility, very few states allow you to do that. They need to have a separate address or a separate building. So I do think there's a way in which, you know, some of the regulation and opportunities can be revised for marijuana, you know, put a little bit more up on hemp, and hopefully there's a way to bring it together. You know, that might be too idealistic, but I think a few months to figure this out, and maybe some changes at the federal level when a lot of states are back in session in January, maybe there'll be new discussions and new opportunities.
Could on that point, would safe banking be an opportunity for them to work together? I mean, the hemp industry, to my knowledge, at least on the derivative side, also has limited access to financial services and banking, right? So safe banking could be broadened for both, or again, that's just too idealistic.
I hope so. I mean, yes, in theory, banking should be easier for hemp because it's not a controlled substance. That said, these are all, you know, private institutions that can do whatever the hell they want when they feel like it. So they can have super restrictive policies on, you know, do they do hemp cannabinoids? Which cannabinoids? Do they only do cultivation? Do they do retail? So yeah, it is still all over the place. So yeah, something like safe banking, if it's able to pass, could be a unifier.
Right. because I saw in one of the Hemp Association websites that they were asking their members or supporters to actually come in and support push for safe banking as a way to that safe banking will include the hemp industry also. But to my knowledge, it does not right now, not as it's written.
No, not as drafted, but there's a lot of, potential trickle down effect that could happen.
So, I mean, my big picture comment here is that it just seems that there's a lot of room for each side to try to agree on some things and work together. But again, seems idealistic.
Yeah, you should have them all on for a fireside chat and see if you can get them all.
Okay, look, I mean, my last question, I have two questions from online that I want to read, and but the last question for you but don't answer yet, is what's your best prediction? What happens with that farm bill, right? But one question from the audience here is: can a state step in and ban products saying that they follow the FDA and therefore close to ban, and therefore they have the right to close and ban certain products until approved by the FDA?
So some states have done that. Some states copy the federal food code, just copy paste. And so they say all interpretations of that food code, they are going to follow FDA. So Massachusetts, for example, their law regulates cultivation and processing, but in terms of finished product, the state's taken the position that they follow FDA, and these cannabinoids cannot be added to food and dietary supplements. So there are still a couple pockets of states, yes, that never set up the regulatory framework for finished product and instead defer to FDA's interpretation because they follow the same food code.
Right. So again, Michelle, thank you very much here for your time. But the last question for you then is your best prediction in terms of what happens with the farm bill. I mean, you can challenge my assumption. My assumption is that they will punt again, meaning that it will be status quo in terms of a farm bill at the federal level, and they will defer to the states. But that's my 2 cents. But you tell me your best prediction in terms of what happens.
I think ask me back on in a couple weeks, because if you get another 1-year extension or a 6 month extension, I think the longer this gets extended out, the more likely it is that the negotiations are going to focus in other areas, in which case I would agree with your prediction of status quo, because there's going to be this intense pressure to get something done quickly, and there's other areas that people might be focusing on that's not hemp. There are a few other areas besides, some people want to, drafts have been released that bifurcate grain and fiber from cannabinoid hemp. All state departments of agriculture asked to raise the limit from 0.3% to 1%, because on the cultivation side, they feel terrible that the genetics aren't stable and the farmers are therefore keep having to destroy the crop in the field. So even the state departments of ag would like to up that number. So there's a lot that could go into it. And I think the longer this drags out, the more likely the focus is going to be off hemp and on other areas of the Farm Bill.
Right, understood. Michelle, thank you very much for joining us today. And again, like we said to the audience, the idea here was a bit of a teaching. I know for a lot of us, it's still a very new subject, but we hope to be doing a lot more work on the subject and the industry and of course how it overlaps with cannabis. Michelle, thank you very much. Any closing remarks?
It's complicated. That's all I got.
All right. Thank you very much. Have a good day, everyone. Thanks, Michelle. Bye.
Thanks, everyone. Bye.